Hello, this is Attorney Mike Gravel. I'm coming to you from an undisclosed location. I got sent this one. It's pretty interesting. We've got an attorney throwing a hissy fit. It's for Meg's Crime Watch. Congratulations to Meg for getting 10,000 subscribers. Let's do this, shall we?
Tickets in the court file this morning. I did not have that person subpoenaed, and based on the arguments that defense have made this morning, I would like to subpoena that court employee and have them testify about what was entered in the system and what was present, based on the arguments defense is making.
I would object, Judge, because this is the third hearing that the city has been aware that the original tickets were not presented to the court. We're ready for trial today, Your Honor.
And we're all about justice, counsel, not ambush or something. So, no, we're all about justice, counsel. We're all about justice. If that was not something that was argued before, because we weren't in court, and I don't know about this argument before. I've not heard that before, but certainly she could respond to something that she didn't know there was going to be an argument.
Can I finish my argument, Your Honor?
Yes.
This will be the third time that she's been here. I am doing this pro bono. My client works for the Detroit Police Department. She's taking time off work to be here. She's taking time off work to read it, but it has no relevance to the actual charges. I don't know what the question is, counsel. If, in fact, the question, if it is not relevant, I'll strike it, but I don't know what it is, so I can't say it's not relevant at this point. But I'll hear it. If it's not relevant or if it's cumulative in some fashion, then I'll strike it.
Thank you, Judge.
Okay, so we start with a reasonable objection, but then he doesn't accept the ruling. That's the problem. When he gets an adverse ruling, he doesn't respect it. I can't tell you the number of times I've been in a hearing, gotten an adverse ruling that I didn't like, and I thought, okay, you carry on. If I'm really that cranky about it, I can appeal it. That's it. There's a record of the whole deal. That's what you do.
Briefly, the question is in response to, or because of defense's opening saying that there was issues post this, that the victim was constantly contacting the defendant, and what was going on between the two of them.
I think you made that part of the argument, counsel. Go ahead.
Judge, it's not Judge.
Yes.
It's not testimony. My opening statement is not testimony.
I know it's not testimony, counsel, but you raised an issue on the record. And if she wants to counter that, then she can do that, because I don't know what your argument is going to be now after that. After you made an opening statement saying what was going to happen, it's relevant. Go ahead.
That's not testimony. What the proper
It doesn't matter, counsel. It's your opening argument. Your opening argument is a roadmap as to what you think the evidence is going to show. And if that roadmap goes askew, she gets to counter it. She gets to say something, because she doesn't know what you're going to.
Judge is absolutely right here. If you brought it up in an opening, then she can ask questions to counter it. And merely for the idea of saying, hey, opposing counsel brought this up in opening and then produce no evidence in favor of it. In fact, here's evidence to the contrary.
Go ahead, counsel.
Judge, I have to put this on the record. I'm sorry. Okay, procedurally, this is done improper. This is completely improper. The proper procedure is to call him as a rebuttal witness if once testimony's on the record.
Improperly. I mean, I hate to be nitpicky, but if you're being nitpicky with everybody else, that's what you get.
Record establishing there's a post discussion.
Also, did you say what the evidence was going to show?
Yes, and Judge, you have to wait for the evidence to show.
So how do I know what your argument is going to show when you close? So you said it, counsel. She gets to address it.
She does not get to address it because it's not testimony. If my client
you get to address it because you said what you're going to show. If you tell the court what you're going to show or what the evidence is going to show, she can say whatever attorney said is going to show, let me show you why it doesn't do that. Yes, counsel, if you make an opening argument saying what the evidence is going to show, she gets to counter that to show that evidence did not show that. You did that, counsel. So
there's no evidence, Judge. And that's the reason why jury instruction says that the attorney's opening arguments and closing arguments are not testimony.
It's not testimony, and it's not, no, it says it's not evidence. It says it's not evidence. But
okay, he's on a very, very bad line here with his argument. He's saying she can't refute what I said in opening statement because I'm not producing any evidence. Well, you're not supposed to be saying things in opening statement where that you don't believe there's going to be evidence to support. So it's a very bad position he's taken here.
If you have told the jury what they're going to see, she can say, this did not happen. So yes, you can do that, sir. So move on. Go ahead, Ms. Rogers.
Thank you, Judge.
She never did?
No.
Do you remember making an oral statement to her on the date of this incident where you demanded her to euthanize her dogs? Yes or no?
No.
Were you aware that you were being video recorded after the incident? Yes or no?
No.
Okay. Let me ask you again, Mr. Kincaid.
So, counsel, let me say this. I do not believe that the lawyer can ask a question and tell them how to answer at all. I do not allow lawyers to tell someone yes or no, because the answer is often not a yes or no answer, even though that's all you want. So I do not require witnesses to respond yes or no. You can ask a question. You can't tell them how to answer in this courtroom. So.
Judge, I'm so sorry, but when I ask a question that requires a yes or no answer, that's what I'm going to say. If it requires an explanation, Ms. Rogers.
Counsel, I don't care what answer you want. The person has a right to answer as long as
I can't fathom this. I can't fathom when I ask a question on whether or not yes or no, did you make...
Wow, he's out of line. First of all, on the issue of whether or not you can demand a yes or no answer, there's a split. Some judges do that, some don't. It's soundly within their discretion. That's the legal answer to this. So if the judge is not allowing that, then that's going to stand. That's how it is. Some judges will allow that. Absolutely. You're not in front of one of those today. He told you what his ruling is. Now you're on the verge of contempt. You're saying, I'm going to go against your order going forward.
So I do this in every trial. I allow the attorneys to ask the question, and I don't tell them, they can't tell a person how to answer. I don't care if you only want a yes or no answer. The answer may not be a yes or no answer. So the person has to answer the question as long as it is responsive to your question, but you can't tell them how to answer in this courtroom. So, and I don't think that is fair to any witness say, I want you to answer it the way I want you to answer it. No, you can ask the question the way you want it. You can't tell them how to answer because the answer may not be complete. Just because you don't want a complete answer, you don't get to tell them how to answer. And that's the rule in this courtroom. In every case, I don't let anyone tell the person, ask the question and tell me, I want to tell you how to answer it. So you can continue.
I mean, Judge, you just handcuffed me. I can't.
No, I didn't. I didn't. No, I didn't. You can answer your question, sir. What you're doing is
you told me that I can't practice law like I've been practicing law for the last 18 years.
I don't care how you've been practicing counsel.
Okay, this is so wrong. First of all, the emotional response is just pathetic. Oh, you just handcuffed me. No, he just gave you an adverse ruling. You're going to have to proceed within his rulings. You're required by law to do that. That's it. If you want to clarify the issue and say, so you're saying that I cannot do this, and you believe you can, just have him affirm that that's what his ruling is and take it up on appeal, if that's what you want to do. But his ruling is clear. You cannot command the witness to say yes or no in his courtroom. And he has the discretion to do so in my judgment. But, you know, whether he does or doesn't is for an appellate court to figure out. But you can't argue post-ruling. Now he's given a ruling on your objection. It's time to ask a question. That's it. That's how this procedure works.
Defend my client's instructions. I'm sorry. I cannot.
What you're saying is, I want to handcuff. Sir, I'm talking now. What you're saying is, I don't want you to handcuff me, but I want to handcuff the witness. I want to ask them a question, and I want to tell them how to answer. No, all I want is a truthful answer. You don't have to tell. They don't have to tell them. It's a truthful answer, sir. It doesn't have to be the way you want it, as long as the answer answers your question, not necessarily how you answer, how you want it. So that's the way we're going to proceed with this. I don't want a no answer. I want a answer that a question the witness can answer the way he wants to answer, as long as it responds to your question.
I do have a procedural question. Has Ms. McAdowell done a written waiver of jury? Does the court know?
No, sir. I am telling you how I conduct my court. Ask the question. Do not tell them how to answer. If the answer is not responsible, strike it.
I can't proceed then. I can't. If the court's going to restrict me on how I have to answer my questions, I can't proceed.
I'm not restricting you on any question.
That is straight up insane. Because if the court doesn't rule the way I want, I can't proceed. Okay, fine. Then you're committing blatant malpractice and arguably contempt of court here. You don't get a choice. You have to proceed. We all have to proceed in the face of adverse rulings that we don't agree with. I've been doing this a long time. If I just rage quit every hearing where I got an adverse ruling, we'd have serious problems.
Judge. You are judge. No. I can't proceed, Judge.
Well, then don't proceed, counsel. But I'm telling you, you can ask any question you want. Just because they answer it in a way that you don't like does not mean you are not able to ask questions.
Can I ask you a question?
Yes, Judge.
Why would you do this?
Well, there you have it. That was a short but wild one. The attorney is completely out of line in this circumstance. His objection is, I've seen that play out many times in courts, this exact fight between a judge and an attorney, ruling one way or the other on the issue of whether or not you can demand a yes or no answer. The answer is, it's in the judge's discretion throughout the country. That is the answer. So carry on and handle it that way. The way you do that is you ask a yes or no question, and then when they go off, you object and you say, Judge, non-responsive. Instruct the witness to answer the question. That's how you do it with a judge that's not allowing you to demand a yes/no question. If they're allowing you to demand a yes/no, then you do it that way. And anyone who's been doing this for more than 5 minutes would know this. It strikes me as very odd. I'm certain that he's been in rooms where they do allow it. But that doesn't bind this judge. Here at Law Talk, we like to have fun with silly stuff that happens in court, and every once in a while, and completely by accident, I assure you, you might learn something. Thanks for watching.